Myanmar wouldn't take him back. He had relatives in Bangladesh and Saudi Arabia, but there was no prospect of him being sent or those countries accepting him. The history of Australia suggested that whenever they had tried to send somebody who had been accused and convicted of such an offense to another country, no other country was prepared to accept him. So now the law did not provide any outer limit. The court said the moment it is clear that he cannot be sent to any other country, he has to be released and the detention has to come to an end, and you can't keep him detained forever and ever. There has to be a reasonable time for such
What's the connection with this case?
My lord, the connection is reasonable time. Even in the case of a convicted offender for crimes against the child, he could not be denied of all civil rights, and Australia doesn't have a chapter on fundamental rights, so they talk about civil and common law rights. He couldn't be denied civil and common law rights forever and retained forever. The other common factor is that there was an earlier decision known as your lordship goes through this judgment, your lordship will see, in the case of 𝐋𝐈𝐕𝐄. In the case of 𝐋𝐈𝐕𝐄, the Australian High Court had said that that person can continue forever. They revisited it and they said that declaration was contrary to the Constitution of Australia.
But Mr. Mathur, your submission is that Samiullah Baloch is to be overruled on the ground that there should be a reasonable time rather than unlimited time. And to carve out that reasonable time argument, your submissions are, in summary?
My lord, my submission is that Samiullah Baloch should be overruled because it reads into 62(1)(f) a civil liability, a declaration of a civil nature, which for the life of the declaration disqualifies a person and thereby strips him of his fundamental right under Article 17 of the Constitution. My lord, I have not used the word lifetime now advisedly.
Mr. Makhloom.
Sorry. My lord, so that's the first submission. The court talks of the doctrine of Tawbah, but then and says this declaration will remain in the field till it is so removed, but does not identify a forum or a law under which this declaration could ever be undone. So neither it identifies a statute, nor it identifies a forum under which would undo this declaration.
Does not identify forum or
mechanism.
Or the law. A law under which such a declaration can be made and a forum which will make that declaration. They don't identify, because my respectful submission is neither such a law nor such a forum exists.
That means that Samiullah Baloch is talking about a window that is through Tawbah for the purpose of election. Yes. Even otherwise, inter parties, the declaration stays.
Yes.
But they're also realizing that for elections there could be a Tawbah system.
Yes.
But that system isn't really there.
That system is not there, that law is not there.
And the judgment talks about mechanism.
It's not there, and my lord, as my lord the Chief Justice identified, this cannot be looked into without looking at Article 175 of the Constitution. When your lordship examines Article 175, paragraphs 1 and 2, all courts, including this honorable court, has only such jurisdiction as is conferred upon it by any law or the Constitution. And that law is not identified, that constitutional provision is not identified.
You mean to say that no special court has been constituted for 62(1)(f)?
My lord, even under 62(1)(f), if a special court is constituted, it has to be done under a law. There is none. So your lordships and no civil court will have a jurisdiction which is not given to it by the Constitution or the law. So
Section 9 of the CPC is procedural or substantive?
My lord, even if your lordship looks at Section 9 CPC as substantive, a Section 9 CPC code will not, in the face of a decree which is described by, or declaration, I don't use the word decree, declaration which is described by this honorable court as permanent and past and closed transaction, applying the principles of res judicata, will not issue a declaration that this declaration no longer applies to this person.
Is that it? Anything else?
My lord, that is it. And
Just one more question. Is there any material which sort of talks about the importance of elections in the sense that people convicted or people having decrees against it, there's this cooling off period and after which they can jump into the ring again? I mean, conceptual framework of this, any material, anything that elections require, that even if you were a convict after a cooling off period, you're still, I mean, democracy requires that you come back into the ring again.
My lord, history gives you that example, which I gave your lordship 2 examples very recently, that history gives you that example. Besides history, I haven't come across, but I'll look for it. My lord, my last submission was, and that's the formulation, that it was submitted yesterday by one of the amici, that your lordships will make this judgment, he didn't say that in so many words, prospective, and it will apply only now to the current election disputes, but it will not do anything about people who had earlier been disqualified as a result of Samiullah Baloch or earlier case law. The submission over there would be that if your lordship was to go down that road, your lordships will be creating 2 classes of citizens in the country, those in whose case a declaration has been made earlier and they have been stripped of their fundamental rights, and those whose fundamental rights are threatened now.
एक चीज मखदूम साहब इसी से रिलेटेड जो सवालात हो रहे हैं जी, जो समीउल्लाह के केस में आया है वो ये आया है कि जब तक वो डिक्लेरेशन कायम और दायम रहेगा, जब तक उसका डिस्क्वालिफिकेशन रहेगी। अब ये जो नया लॉ 232 में आया है, कैन वी रीड इट लाइक दिस कि ये जो वो वाली बात थी वो उन्होंने परमानेंट नहीं कहा, उन्होंने कहा एज लॉन्ग एज द डिक्लेरेशन विल रिमेन इन फील्ड। हम ये कह सकते हैं कि इस लॉ के आने के बाद उस डिक्लेरेशन की मुद्दत उन्होंने 5 साल कर दी।
सिर्फ elections.
Yes, my lord, your lordship
to the
may,
extent of election.
your lordship may, but my respectful submission remains. My respectful submission remains that
I
your
see
lordship.
you are very hesitant to go that path.
My lord, I spent several days unsuccessfully arguing in another case, so I'm in a way, I've got a mental block saying that a statute, my lord, your lordship's judgments are there. Your lordship will find every reason to uphold the validity of a statute. Even only when reasoning completely fails your lordship, would your lordship strike it down. When there are 2 interpretations possible, your lordship will give an interpretation. The burden of proving a statute unconstitutional is upon the person who comes to this honorable court and says this statute is unconstitutional. Now, in order to apply those, now even if your lordship is to uphold the statute.
It was just a comment.
No, my lord,
Carry on with your
No, but one more question which arises from that is that there's a bit of an unease when we look at 232. Can, through sub-constitutional legislation, the constitutional provision be controlled? I just want your comment on that.
My lord, my submission is twofold.
Maybe we have just considered this very point in the Supreme Court Practice and Procedure
Yes, Your Lordship.
Act, which was a full court where the right of appeal was created by a statute, not by the Constitution. Is that an answer or not an answer?
My lord, that's one answer, and your lordship gives another answer in that case as well, where your lordship
That judgment is binding on us.
that and your lordship says that we will not deal with academic questions. Questions which do not arise, we will not decide in this case. Number of issues were raised. Your lordships in the penultimate paragraph, Practice and Procedure Judgment.
Yeah, it was very interesting hearing. It was,
Your lordship-
we would have loved to, but
No,
like you
my lord,
said it, save it for another day.
Yes, my lord, and I would therefore say, my lord,
Can you also just, I know it may be imposed, give a little write-up today?
my lord, a write-up
Not
is
too long,
ready.
just precise
Yes,
what
ma'am.
you formulated,
And may I just-
so we don't want to miss anything out.
Before leaving the rostrum,
He has the right to.
You are a mind reader.
my lord,
Have you done it already?
That note is there. Your lordship may also take a look at this chart, and then I leave the rostrum. Paragraph 34 of your Lordship's judgment, full court judgment, having found the Act to be fully compliant with the Constitution, there is no need to consider the other points raised by the petitioners because the same will have no bearing on the outcome of these cases. So a declaration as to 232 will have no bearing on the outcome of these 185 appeals. If your Lordship overrules Samiullah Baloch, the disqualification will get removed. If your Lordship confirms Samiullah Baloch, the disqualification is then upheld.
इसको रीड डाउन क्यों नहीं कर सकते?
My Lord, because the issue is not before me.
अब वही बात वही आ रही है ना कि उसमें परमानेंट डिस्क्वालिफिकेशन तो नहीं है, उसमें लिखा है एज लॉन्ग एज द डिक्लेरेशन विल रिमेन इन फील्ड. अगर बाय लेजिस्लेशन उसको वो कहते हैं कि डिक्लेरेशन की जो मुद्दत है जो उसमें लिखी हुई है उस 62F के अंदर वो हम 5 साल कर रहे हैं, तो वो फिर उनका jurisdiction है या नहीं है?
My Lord, academically I would say yes, but practically I would say that your Lordships will perhaps do that in a proper case where somebody challenges that before your Lordship.
No, we are just approving. Challenge तो नहीं हो रहा हमारे सामने. उसकी legality पे तो हम बात नहीं कर रहे हैं ना, वो तो एक in existence है law, उसके ऊपर बात कर रहे हैं.
जी chart. My Lord, your Lordship may also look at a chart which I have briefly done, which basically, your Lordship has that chart before you. Your Lordship will see I have put on the left-hand column judgments with members of Parliament were disqualified and judgments where members were not disqualified. And your Lordship will see, particularly when your Lordship will see the case of Imran Khan Niazi is here, Sheikh Muhammad Akram, a judgment authored by my Lord the Chief Justice is there on the right-hand side column. If your Lordship turns the pages, your Lordship will see after Samiullah Baloch, there are several judgments. The case of Shakil Awan, the case of Roshan Ali Bariro, the case of Khaja Muhammad Asif, the case of Sardar Muhammad Rind, or in the case of Shamuna Badshah, the case of Faisal Wabda lastly, where the learned author judge of Samiullah Baloch has slowly moved away from the rigors of the Samiullah Baloch test. So therefore that shows that there was a judicial realization without overruling by the author judge himself, because he couldn't overrule.
Maybe the council had argued better.
Maybe that's true, sir. But Samiullah Baloch therefore sends considerably diluted. Now your Lordship need to pull that jurisprudence together, because there are judgments for, there are judgments against. Your Lordship has to see if Samiullah Baloch is incorrectly decided, then there is no bar under 62(1)(f).
Anything else?
That's it.
Mr. Maktoum, before leaving the sir.
ये आप points अगर जो आपके articulate अगर एक छोटा सा 1-2 पेज पे अगर आप हमें दे दें during the course of the day.
Sir, it will be done today.
एक जरा सी फैक्चुअल बात भी है, सवाल पूछ रहा हूँ. क्या जितनी भी जजमेंट्स आई हैं जिसमें समीउल्लाह बलोच को इम्प्लीमेंट किया, इवन समीउल्लाह बलोच में ही, क्या किसी भी केस में किसी सिविल कोर्ट से ऐसी डिक्लेरेशन आई है कि जिसके तहत उस शख्स को डिक्लेयर कर दिया हो कि वो नहीं, और उसकी बुनियाद पर उसको लाइफ डिस्क्वालिफिकेशन और वो नहीं किया हो?
No, man. No, man. Not that I am aware of.
Just adding to the query, has any court revived the ban or removed the ban? To kind of through court of law, like a court of law can give a declaration, court of law gives a declaration, okay, now you are honest, Amin. मेरे नजर से ऐसा केस गुजरा नहीं.
There is not a single case. Civil judgments are not reported, so I'm not aware. But there is certainly nothing which was reported in the High Court. And my Lord, a High Court judge would be particularly very worried of undoing such a declaration, because he would worry under 209(25) of the Constitution, that 25A, that his sanity may be called into question, and therefore he's continuing to hold the office.
एक बात और, समीउल्लाह बलोच में
Why you calling the sanity of judges into question or not counsel as well?
Yes, my Lord.
ये आप हम पे ही सब डाल रहे हैं चीजें.
Sir, नहीं, फर्क ये है कि if my sanity is called in question, that doesn't lead to a loss of office.
मिस्टर मखदूम, जरा ये बताना मिस्टर मखदूम, ये समीउल्लाह बलोच में जो पिटिशनर है या रिस्पोंडेंट उस केस में थे, उनके बारे में कोई लफ्ज कहा गया कि उनके बारे में ये डिक्लेरेशन इवन सुप्रीम कोर्ट ने कोई दी हो? जस्ट प्रिंसिपल उन्होंने कह दिया.
My lord, it hasn't been said that they are profligate or they are dishonest or they are not Sadiq or Amin.
Nothing has been said against the.
There is no such declaration. And your lordship will see the disconnect. Mia Mohammad Nawaz Sharif is disqualified for not for a. I leave that.
I don't want involvement of names. We are only doing with the
Let's
constitution.
not give a name, my lord.
Cheek.
A person is disqualified.
We don't want to make it a political.
A person is disqualified
Ji.
who has not drawn a salary because the salary is regarded in asset. A person is disqualified
That case is not before us.
because he's a trust, which trust his children had declared he is not, but a person is not disqualified.
Maktoum Ali Khan, the first rule of council is don't argue a case for which you've not received a fee.
My lord, I have finished my submission.
Thank you.
Has everything been said or you want to add?
I want to say.
How long for?
I'm in your hands, but
No, we don't want to stop you.
I
Just tell us.
understand there is a reference at 11:30. I try to wrap up by 11:30.
There's a break also.
नहीं, थोड़ा ये नहीं कि आप हमें वहां तक खींच के ले जाएं, ब्रेक भी, या तो हम उसके बाद
मेरा
बैठ
कुछ
सकते
time extend हो
हैं,
गया,
अगर
I was hoping to
आपके
get
पास
some
लंबा वक्त है तो हम उसके बाद बैठ
After the
सकते हैं।
reference.
जी ठीक है.
तो आप ज्यादा टाइम लेंगे?
जी मुझे कुछ तो लगेगा भाई.
अच्छा, किसी तो हम पूछ रहे थे कोई और तो नहीं है? एक शॉप थे, उनको कुछ कहना था कि हम कम से कम सबको खत्म कर लें, फिर आपको रहने देते हैं जी।
Well, I have two CMs, CMA 3 and CMA 21.
बताएं क्या चाह रहे हैं इसमें?
Sir, इसमें I filed the concise statements in response to the orders passed by this honorable court. So I adopt the arguments of Mr. 𝐋𝐈𝐕𝐄 Ali Khan. Thank you.
You are supporting the law. Supporting the law, ना?
As is argued by Mr. 𝐋𝐈𝐕𝐄 Ali Khan.
आपका नंबर क्या है? CMA?
CMA 3,
हाँ?
CMA 3
और
and 21.
21.
Yes, my lord.
ठीक। ओके, आप हो गए। और
सीएम में 22 सुप्रीम कोर्ट वाली वो मैंने विड्रॉ करनी है, इंस्ट्रक्शंस विड्रॉ
अच्छा, विड्रॉ
चैम्बर
हम देख लेंगे, ठीक है। और
योर ऑनर, मेरी सीएम 18 है। मुख्तसर सी सबमिशन है कि when the legislature through 18th amendment introduced declaration in the article 62, parliament presumed that everyone is honest, everyone is amin, everyone is non-profligate, and unless there is a declaration, he shall be presumed as such. So this was the basic presumption, and that is rebuttable. Anyone who want to rebut that,
आप अपना बताएं ना, आपका क्या मौकिफ है?
जी, जो अभी ला है उसका
आपका मौकिफ क्या है?
मेरा मौक़िफ़ ये है कि बिल्कुल हर आदमी सादक अमीन है जिस वक्त तक के साबित
Let's prove otherwise.
यस। और फिर जब वो उसने कोई ऐप कर दिया एक दो इंस्टांसेस से,
Everybody is assumed to be innocent unless proven guilty. That sort of concept.
और फिर एक दो इंस्टांसेस से कोई झूठा भी नहीं हो जाता, एक दो इंस्टांसेस पे अगर वो फजूल खर्ची करता है वो प्रॉफिगेट भी नहीं साबित हो सकता, एक दो वाकयात से नहीं, ये उसका मुसलसल कंडक्ट साबित करेगा डिक्लेरेशन के टाइम।
और ऐसा हर शख्स गलती का पुतला है।
बिल्कुल। और जब डिक्लेरेशन आ भी गया तो फिर भी तौबा के दरवाजे के लिए उन्होंने मुद्दत मुकर्रर कर दी 5 साल वैलिडिटी, जैसे किसी लाइसेंस की भी वैलिडिटी है, उस डिक्लेरेशन की वैलिडिटी लेजिस्लेचर ने 5 साल कर दी है। अब 5 साल के बाद अगर कोई आदमी फिर भी कहता है कि ये सादक अमीन नहीं है तो वो दोबारा जाके डिक्लेरेशन ले ले कि इसको 1 आ गया डिक्लेरेशन, इसने फिर भी अपने आप को तौबा के दरवाजे तक नहीं लेकर गया, अपने आप के अपना रास्ता मेंड नहीं किया, he is not meditant, he is still not सादक and अमीन, और he is still profligate, he is still dishonest, तो वो ले आए दोबारा, वरना 5 साल के बाद दोबारा प्रिज्यूम ये किया जाएगा कि ये इसने तौबा कर लिया।
Thank you. जी
CMA 135, my lord. May I adopt the arguments by the petition? And I support the law.
CMA number?
CMA number 135
अच्छा, ठीक
of
है।
22.
ओके, ठीक है। शॉर्ट एंड स्वीट। नेक्स्ट।
My lord, I'll just briefly
CMA
touch-
number बता दें।
My lord, it's civil appeal number 1946 2020. 1946
सिविल, आपकी सिविल अपील है।
civil appeal, my lord, of 2020.
You are supporting Samila Baloch or opposing?
I'm opposing.
Opposing Samila Baloch.
My lord.
So you adopt everything said
My lord, but just briefly, if I can just add.
Want to add anything, bata de.
My lord, if I may just refer Article 62(1)(f), and I just would like to add that this article is conjunctive and not disjunctive. So all the requirement mentioned in F, sagacious, righteous, non-profligate, honest and Amin, has to have a degree of all of it.
Sorry.
My lord, because it's not or, it's and. This is my humble submission.
Okay, conjunctive and not disjunctive.
My lord.
Ji.
Number one, and my lord, in this regard, there is no such declaration till today, at least I have not come across. However, so many people have been disqualified. There has not been declaration to this effect in Pakistan.
Conjunctive nahi hua hai aaj.
Or even otherwise, there has not been a declaration saying that this X person is not Sadiq Amin or honest.
Ji.
Further, my lord, I would like to state Article 63(1)(h), which talks about has been on conviction of moral turpitude. In my humble understanding, I would say that if somebody is convicted in this, say for example, somebody is a thief and is convicted for it, then he's automatically disqualified under 62(1)(f) also. If he's a thief, how could he be honest and Amin? My lord, and further, I would like to say that Article 62(1)(f), the declaration to this effect cannot be given by constitutional courts, and it can only be given by the election tribunal. And because declaration has to be on finding of fact, after leading evidence cross. Because if it is held today that under Article 199...
Evidence has to be led.
My lord.
And cross-examine right has to be provided.
My lord, because if you are declaring somebody not honest...
Article 10A requirements.
Article 10A requirement, exactly.
Forum is tribunal.
My lord.
मतलब जो भी फोरम है उसमें ये तकाजे पूरे करना चाहिए एविडेंस लीड हो क्रॉस एग्जामिनेशन हो राइट टू लीड एविडेंस इन रिबटल हो
माय लॉर्ड
ठीक
now my lord quickly if I just come to 𝐋𝐈𝐕𝐄 judgment and take my lords to page 442 para 32
जी
In this, it has been stated that declaration by court of civil jurisdiction at para 32, fifth line. They have said that it has to be declaration by court of civil jurisdiction.
Paragraph 32.
32, my lord. In my humble opinion, that would be...
कहाँ से पढ़ रहे हैं?
My lord, fifth line है. 1, 2, 3, 4, fifth line.
पढ़िए हाँ civil jurisdiction as declared
by court of civil jurisdiction. So in my submission that would be violative of Article 225 of the Constitution, which says no election dispute can be brought in question other than by election petition. And
civil court can declare before election, even if no dispute of election is there, somebody can be declared.
My lord, in my view, that is why that has been safeguarded so that the parliamentarians don't have to be stuck with these court cases throughout their 5 years tenure. Why election tribunal? Because only the contesting candidate can challenge those elections. Here,
even if civil court declares somebody, then still the tribunal can decide about it.
My lord, in my view, if civil court, anyone can go and take you to the court, and all 5 years of your tenure, you will be busy in courts proceeding only. Whereas in election tribunal, it's only the election candidate who have contested the elections, they can challenge that election. Mr. My lord, at page 443, if my lord would see para 34. If I may just quickly read this, my lord. In the post-18 constitutional amendment scenario, an adverse declaration by court of law against a candidate necessary to oust him from an election. It was held in Abdul Ghaffur Lahiri versus returning officer that a false declaration made in nomination paper by candidate about his academic qualification led to permanent embargo on the candidature for election. This is because Article 62 of the Constitution did not provide any period for which a person would stand debarred from contesting election, and therefore the appellant before the court could not become qualified merely by a flux of time. To the same effect, is the judgment of Mohammad Khan Junejo versus Federation of Pakistan, appellant before you, my lord, wherein a deficiency in qualification under Article 62(1)(f) of the Constitution led to permanent disqualification. This outcome was followed in Aladino Bhayo's case, 2013 SCMR, in which the following observations were made in respect to duration of embargo. In this Aladino Bhayo case, relying on Mohammad Khan Junejo's case, who was appellant before my lord, it was said that this disqualification will haunt him forever. However, what happened after that in 2020? Supreme Court 591, relevant page 15, 597.
G.
Class term A, my lord. The para 5, the upshot of the said judgment is that a disqualification under 62(1)(f) of the Constitution can only be imposed by or under declaration made by court of law. By such prescription, Article 62(1)(f) creates a lawful, transparent and fair mechanism for an election candidate to contest an allegation that he is disqualified under one or more of the ground listed in the said constitutional petition. Accordingly, in the case of Sardar Yar Mohammad Rain, this court held that judicial declaration disqualifying a candidate under 62(1)(f) of the Constitution must necessarily be based on oral or documentary evidence. In case reported at Imran Khan Niazi versus Mia Mohammad Nawaz Sharif.
Point kya hai?
My lord, point is, my lord, at para 7, I was just showing that this was the view. From here, the view started changing. At para 7, if my lord would see at the next page, third last line.
G.
The said impact of the 18th Amendment went unnoticed in our judgment under review, dated 9/7/23, thereby constituting an error apparent on the fact of record. What I would like to say here is, my lord, in this case, they realized that this was an error apparent on record, and they reviewed the judgment of 2013, which was passed relying on our appellant's judgment. But appellant and rest, everybody else was left there. In this case, this judgment was reviewed and that judgment was set aside.
Bhayo review was after Samiullah Baloch.
My lord, 2020.
Acha.
My lord. And Bhayo was passed relying on the judgment of Mohammad Khan Junejo's case.
Bhayo review after Samiullah Baloch.
After Samiullah Baloch.
And a different point of view was taken there.
Yes, my lord.
What was the view there?
The point of view was that after 18th Amendment, the Supreme Court had not realized and Supreme Court had declared.
To kya hold kya kiya?
Hold kya, they set aside that judgment and said that in post 18th Amendment scenario.
Disqualified or qualified candidate?
He's qualified.
Disqualified.
Qualified. Earlier in 2013 he was disqualified. In review judgment in 2020 it was held that it was a mistake.
Okay, understood.
Because there wasn't a declaration from
We will read it. Thank you.
So this was the case in the, and in this I was saying that in Mohammad Khan Junejo's case, in which Bhayo was disqualified, Bhayo case was reviewed and rest everybody was left there.
ठीक. ये रिव्यू वाली बेंच कितने जजेस की थी?
My lord, 3-member bench.
ठीक.
And in Yar Mohammad Rind, it was also 3-member, but all 3 members were same of as in Samiullah Baloch case. Now, my lord, if I may just quickly take my lords to Faisal Wavda's case, 2023 SCMR 370. Paragraph 4, my lord. Sixth line. He admitted that he was disqualified from contesting the election under Article 63(1)(c) of the Constitution on the date when he had filed nomination papers for the election of NA 249 Karachi, and that his affidavit filed with the nomination paper thus contained an erroneous statement which he regrets. In order to demonstrate his good faith and remorse for his mistake, he undertakes that he will resign from the office of member of the Senate to which he was elected. Then next para, second last line, it is clarified that petitioner shall not be considered disqualified in any subsequent election on the basis of instant matter. In my view, my lord, this was the, in my humble view, this was the correct view taken rather than Samiullah's Baloch case.
Thank you. Conclude.
My lord, इसमें सिर्फ एक last point. Section 232(2), my lord, though the viries are not challenged and not before, my lord, I would like to state that this 232(2) does not take anything away from Article 62(1)(f).
It accords with Article 60.
My lord. And my lord has already pointed out that
we have not pointed, we just observed.
No, reliance is also placed on the Supreme Court's procedure judgment.
Okay, that point.
My lord. This is all.
Thank you. क्यों कहीम साहब कुछ रह गया? आप थके हुए लग रहे हैं.
I'll just take 2 minutes, my lord.
जी बता दें. कौन से केस में आप?
My lord, I'm in Civil Appeal 880.
880. Which proposition are you supporting?
My lord, I'm supporting the law.
The law. As always, you support the law.
My lord, I'm submitting before my lord that Article 17 has been interpreted by this honorable court in the Benazir Bhutto cases. Muhtarma Benazir Bhutto cases.
Article 17, Benazir Bhutto case is 19.
My lord, there are 3 of them, my lord.
Which one are you referring to?
To include the right to, my lord, right to contest elections and all of the
citation दे दें.
Sir, the first one was PLD 1989 Supreme Court's.
Which one are you referring to?
My lord, I am referring to, my lord, PLD 1998 Supreme Court 388.
1998 Supreme Court.
388.
Which page?
At paragraph 165, my lord.
Para 165. ठीक है हम पढ़ लेंगे.
My lord, इसके अंदर ये होल्ड किया गया है कि fundamental right to it includes the Article 17 includes the right to contest elections as well. Right of association के अंदर add किया गया. I'm submitting before this honorable court that 62(1)(f) की sir जो declaration है, the declaration is about one point in time. It cannot be said that even if it is permanent, it states कि उस particular time के ऊपर आप सादिक और अमीन नहीं हैं. It cannot be held कि there is no principle of original sin in Islam. That अगर एक दफा आप बीच में हो गए तो वो बाद में नहीं हो सकता. What I'm submitting before this honorable court is that the entire tenor of the election laws, अगर Elections Act 2016 देखा जाए और अगर रोपा भी देखा जाए सर, उसका जो section 67 है वो disqualification के बारे में बिल्कुल बात नहीं करता. वो election को set aside करने के लिए सर बात करता है. Disqualification is used as a basis for setting aside the election once. I am respectfully submitting that any disqualification which follows from such an interpretation or a declaration, if such a declaration could be given, would only be one time and would double punishment नहीं हो सकेगी इस particular case के अंदर. And I am also submitting before this honorable court that in the Mubashir Hassan case, the NRO judgment, it was specifically stated that 62(1)(f) is not a self-executing provision. What is relevant is the mechanism for its enactment, जो कि impugned जो law भी जनाब के सामने मौजूद.
हसन वाला केस की citation.
My lord, Mubashir Hassan, it's at page 423, and my lord, the citation is PLD 2010 Supreme Court 265, paragraph 115.
Para 115.
My lord, and it was stated that this is not a self-executing provision. In fact, a mechanism has been provided, and the law which is before my lords has stated कि इसका procedure और forum provide किया जाएगा. सिर्फ टाइम को उन्होंने टच किया है, but they have not gone ahead and provided the provision. So my respectful submission would be that the forum which is under 62(1)(f) to give the declaration is yet to be provided. No redundancy is being attributed to the Constitution. However, the mechanism which is supposed to be provided is yet to be provided by the legislature. My Lord, on the issue of Tawbah and Afo Darguzar, I have actually done some homework in provisions of the Quran. I have actually Mukhtalif surahs I have highlighted. I'm tendering the same before my Lord in my concise statement.
Thank you, will be most useful.
Thank you very much, sir.
ये ले लें इनसे। ठीक है, तो we come to the Attorney General at 11 after the
Supreme Court bar.
हाँ, sorry.
सर सुप्रीम कोर्ट सर हम विड्रॉ करना चाहते हैं सर हमारी चैम्बर अपील
आपकी क्या चीज थी 184 था
हमारी 184 था
अच्छा ओके यू आर विड्रॉइंग
जी सर
सीएमए
CMA है सर 22 सर ऑफ 2020
नहीं वो कह रहे हैं विड्रॉ कर रहे हैं
विड्रॉ कर रहे हैं सर
चेंबर अपील थी
जी सर चैम्बर
अपील विड्रॉ जी
माय लॉर्ड मैंने भी इसी इशू पे कुछ रिसर्च की थी इफ माय लॉर्ड्स आर इंटरेस्टेड वो पेपर बुक्स में देना चाहता हूं
Of course we are interested. Please, your research we don't want to discard. We'll certainly read it.
सीएमए नंबर 8 में मेरी कंसाइज स्टेटमेंट है माय लॉर्ड्स और उसकी जो जजमेंट्स हैं वो
सीएमए आपकी क्या है?
सीएमए नंबर 8 ऑफ 2024
8 of 2024 और रिसर्च डॉक्यूमेंट ठीक है थैंक यू वेरी मच आप चाह रहे हैं कि हम कोई काम ही ना करें और नहीं थैंक यू सर जस्ट ऑन लाइटर नोट
क्यूरेटिव प्रिंसिपल के ऊपर हैं
thank you for the very valuable assistance Attorney General if anybody is left over or the Attorney General we'll hear after the reference after Friday prayers ठीक है
मेरा
हम आ रहे हैं वापस
in response to Maktouma की खास समाज
सर इसमें
बाद में हम यस
सर, public
11:30 आप लोग मौजूद रहिएगा हाँ वो बता देंगे ना हम रेफरेंस ही बता देंगे
Well, Mr. Chairman, and to the members, what my rule would do is actually what we've been doing under the discussion of the rules of this committee. For the freshmen who are just here, people who've watched committees, obviously for my colleagues who have been here for a very long time, the process of all the committees in Congress has typically been seniority recognition. So the members typically